Remedial Law Q&A Part 2. What is a subpoena? It is a process directed to a person, requiring him to attend and to testify at the hearing or the trial of an action or at any investigation conducted under the laws of the Philippines or for taking of his deposition. How is service of subpoena made? It shall be made in the same manner as personal or substituted service of summons. Note: services of a subpoena shall be made by the sheriff, by his deputy, or by any other person specially authorized who is not a party and is not less than 18 years of age. What is an interlocutory order? Those that determine incidental matters that do not touch on the merits of the case or put an end to the proceedings. That is, order denying a motion to dismiss, granting an extension of time, or authorizing an amendment. Note: appeal is not proper to question an interlocutory order. The proper remedy to question an interlocutory order is a petition for certiorari under Rule 65. Is a second motion for reconsideration allowed? A second motion for reconsideration is not allowed. The prohibition on a second motion applies only when the motion is directed against a judgment or a final order. The rule does not apply to a motion for reconsideration of an interlocutory order. What kind of judgments and final orders are subject to appeal? An appeal may be taken only from judgments or final orders that completely dispose of the case. An interlocutory order is not appealable until after the rendition of the judgment on the merits. What courts have jurisdiction over the following cases filed in Metro Manila? A. An action for specific performance, or in the alternative for damages in the amount of 180,000. B. An action for a writ of injunction. C. An action for replevin of a motorcycle valued at 150,000. D. An action for interpleader to determine who between the defendants is entitled to receive the amount of 190,000 from the plaintiff. In letter E, a petition for the probate of a will involving an estate valued at 200,000. Answer to letter A. An action for specific performance, or in the alternative for damages in the amount of 180,000 falls under the jurisdiction of Metropolitan Trial Courts in Metro Manila. Although an action for specific performance is not capable of pecuniary estimation, since the alternative demand for damages is capable of pecuniary estimation, it is within the jurisdiction of the Metropolitan Trial Courts in Metro Manila. Section 33 of BP 129 as amended by RA 7691, Cruz v. Tan. Letter B. An action for injunction is not capable of pecuniary estimation and hence falls within the jurisdiction of the regional trial courts. Letter C. An action for replevin of a motorcycle valued at 150,000 falls within the jurisdiction of Metropolitan Trial Courts in Metro Manila. Letter D. An action for interpleader to determine who between the defendants is entitled to receive the amount of 190,000 falls within the jurisdiction of the Metropolitan Trial Courts in Metro Manila. Makati Development Corporation v. Tanwako. Letter E. A petition for the probate of a will involving an estate valued at 200,000 falls within the jurisdiction of the Metropolitan Trial Courts in Metro Manila. Additional answer to letter B. An application for a writ of preliminary injunction may be granted by a municipal trial court in an action of forcible entry and unlawful detainer. Day v. RTC of Zamboanga. A files an action in the municipal trial court against B, the natural son of A's father, for the partition of a parcel of land located in Taytay, Rizal, with an assessed value of 20,000. B moves to dismiss the action on the ground that the case should have been brought in the regional trial court because the action is one that is not capable of pecuniary estimation, as it involves primarily a determination of hereditary rights and not merely the bare right to real property. Resolve the motion. The motion should be granted. The action for petition depends on the determination of the hereditary rights of A and B, which is not capable of pecuniary estimation. Hence, even though the assessed value of the land is 20,000, the municipal trial court has no jurisdiction. Rosal versus Vestil. Q. In 1996, Congress passed Republic Act No. 8189, otherwise known as the Voters Registration Act of 1996, providing for computerization of elections. Pursuant thereto, the Comelec approved the Voters Registration and Identification System project. It issued limitations to pre-qualify and bid for the project. After the public bidding, Photokina was declared the winning bidder with a bid of $6 billion and was issued a notice of award. But Comelec Chairman Jenner Go objected to the award on the ground that under the Appropriations Act, the budget for the Comelec's modernization is only $1 billion. He announced to the public that the VRIS project has been set aside. 2 commissioners sided with Chairman Go, but the majority voted to uphold the contract. Meanwhile, Photokina filed with the RTC a petition for mandamus to compel the Comelec to implement the contract. The Office of the Solicitor General, OSG, representing Chairman Go, opposed the petition on the ground that mandamus does not lie to enforce contractual obligations. During the proceedings, the majority commissioners filed a manifestation that Chairman Go was not authorized by the Comelec and Bank to oppose the petition. 2006 Bar Question. May the OSG represent Chairman Go before the RTC, notwithstanding that his position is contrary to that of the majority? 5%. Yes, the Office of the Solicitor General can represent Chairman Go before the Regional Trial Court. The OSG is an independent office. Its hands are not shackled to the cause of its client's agency. In the discharge of its task, the primordial concern of the OSG is to see to it that the best interests of the government is upheld. Comelec versus Quijano Padilla. Q. Does the Court of Appeals have jurisdiction to review the decisions in criminal and administrative cases of the Ombudsman? 2006. The Court of Appeals can only review the decisions of the Ombudsman in administrative cases in an appeal by petition for review under Rule 43 of the 1997 Revised Rules of Civil Procedure. It has no jurisdiction to review decisions of the Ombudsman in criminal cases, the proper remedy being to file with the Supreme Court an original petition for certiorari under Rule 65, Fabian versus Ombudsman Desierto, Quizon versus Ombudsman Desuerto, and Mendoza Arce versus Ombudsman. Q. P sued A in the RTC Manila to recover the following sums of money. 1. 200,000 on an overdue promissory note. 2. 80,000 pesos on the purchase price of a computer. 3. 150,000 for damages to its car. And 4. 100,000 for attorney's fees and litigation expenses. Can A move to dismiss the case on the ground that the court has no jurisdiction over the subject matter? No, because the RTC Manila has jurisdiction over the subject matter. P may sue A in one complaint asserting as many causes of action as he may have, and since all the claims are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction. Rule 2, Section 5. The aggregate amount claimed is $430,000, exclusive of the amount of $100,000 for attorney's fees and expenses of litigation. Hence, the RTC Manila has jurisdiction. Give the effects of the following. A. Splitting a single cause of action. And what's the end? Non-joinder of a necessary party. These are asked in 1998 bar. Letter A. The effect of splitting a single cause of action is found in the rule as follows. If two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment on the merits in one is available as a ground for the dismissal of the others. Section 4 of Rule 2, 1997. Letter B. The effect of a non-joinder of a necessary party may be stated as follows. The court may order the inclusion of an omitted necessary party if jurisdiction over his person may be obtained. The failure to comply with the order of his inclusion without justifiable cause is a waiver of the claim against such party. The court may proceed with the action, for the judgment rendered shall be without prejudice to the rights of such necessary party. Q. Perry is a resident of Manila, while Ricky and Marvin are residents of Batangas City. They are the co-owners of a parcel of residential land located in Pasay City with an assessed value of $100,000. Penny borrowed $100,000 from Ricky, which he promised to pay on or before December 1st, 2004. However, Perry failed to pay his loan. Perry also rejected Ricky's and Marvin's proposal to partition the property. Ricky filed a complaint against Perry and Marvin in the Regional Trial Court of Pasay City for the partition of the property. He also incorporated in his complaint his action against Perry for the collection of the latter's 100,000 peso loan, plus interest and attorney's fees. Stated with reasons whether it was proper for Ricky to join his causes of action in his complaint for petition against Perry and Marvin in the Regional Trial Court of Pasay City, 2005. Bar question. It was not proper for Ricky to join his causes of action against Perry in his complaint for petition against Perry and Marvin. The causes of action may be between the same parties, Ricky and Perry, with respect to the loan, but not with respect to the partition, which includes Marvin. The joinder is between a petition and a sum of money, but the petition is a special civil action under Rule 69, which cannot be joined. Section 5, Rule 2, 1997 Rules of Civil Procedure. Also, the causes of action pertains to different venues and jurisdictions. The case for a sum of money pertains to the municipal trial court or the municipal court and cannot be filed in Pasay City because the plaintiff is from Manila, while Ricky and Marvin are from Batangas City. Rule on implied institution of civil action with criminal action. Q. While cruising on a highway, a taxicab driven by Mans hit an electric post. As a result thereof, its passenger Jovi suffered serious injuries. Mans was subsequently charged before the municipal trial court with reckless imprudence resulting in serious physical injuries. Thereafter, Jovi filed a civil action against Lourdes, the owner of the taxicab, for breach of contract, and Mans for quasi-delict. Lourdes and Mans filed a motion to dismiss the civil action on the ground of litis pendentia, that is, the pendency of the civil action impliedly instituted in the criminal action for reckless imprudence resulting in serious physical injuries. Resolved the motion with reasons. 2005. Being a distinct cause of action, the action for breach of contract against the taxicab owner cannot be barred by the criminal action against the taxicab driver, although the taxicab owner can be held subsidiarily liable in the criminal case if the driver is insolvent. On the other hand, the civil action for quasi-delict against the driver is an independent civil action under Article 33 of the Civil Code and Section 3, Rule 111 of the Rules of Court, which can be filed separately and can proceed independently of the criminal action and regardless of the result of the latter. Samson versus the Y. Q. Defendant X received an adverse decision of the Regional Trial Court in an ordinary civil case on January 2, 2003. He filed a notice of appeal on January 10, 2003. On the other hand, Plaintiff A received the same decision on January 6, 2003, and on January 19, 2003, filed a motion for reconsideration of the decision. On January 13, 2003, Defendant X filed a motion withdrawing his notice of appeal in order to file a motion for a new trial, which he attached. On January 20th, 2003, the court denied A's motion for reconsideration and X's motion to withdraw notice of appeal. Plaintiff A received the order denying his motion for reconsideration on February 3, 2003, and filed his notice of appeal on February 5, 2003. The court denied due course to A's notice of appeal on the ground that the period to appeal had already lapsed. A. Is the court's denial of X's motion to withdraw notice of appeal proper? B. Is the court's denial of due course to A's appeal correct? 2003. Letter A. No. The court's denial of X's motion to withdraw notice of appeal is not proper, because the period of appeal of X has not yet expired. From January 2, 2003, when X received a copy of the adverse decision up to January 13, when he filed his withdrawal of appeal and motion for new trial, only 10 days had elapsed, and he had 15 days to do so. Letter B. No, the court's denial of due course to A's appeal is not correct, because the appeal was taken on time. From January 6, 2003, when A received a copy of the decision up to January 19, when he filed a motion for reconsideration, only 12 days had elapsed. Consequently, he had 3 days from receipt of February 3, 2003, of the order denying his motion for reconsideration, within which to appeal. He filed his notice of appeal on February 5, or only 2 days later. Alternative answer. Letter B. Since A's motion for reconsideration was filed on January 19, 2003, and it was denied on January 20th, it was clearly not set for hearing with at least 3 days' notice. Therefore, the motion was pro forma and did not interrupt the period of appeal, which expired on January 21, 2003, or 15 days after notice of the decision on January 6. When is substituted service of summons proper? In our jurisdiction, for substituted service of summons to be valid, it is necessary to establish the following. 1. The impossibility of service of summons in person within a reasonable time. 2. The efforts exerted to locate the person to be served. And 3. Service upon a person of sufficient age and discretion in the same place as the defendant or some competent person in charge of his office or regular place of business. Sabia Jr. versus Hamilton versus Levy, GR 139283, November 15, 2000. Q. The substituted service of summons upon defendant MU was clearly defective because the sheriff's return did not contain any statement or explanation regarding the impossibility of personal service. After CAT, the plaintiff filed a motion with notice of hearing for the executioner. The trial court's decision, MU filed a motion for resetting of the court's hearing thereon. Was the defect in substituted service of summons so that the court already acquired jurisdiction over MU when the latter filed his motion? No. Jurisdiction over the person of a defendant may only be acquired by the filing of the petition in case of the plaintiff, or by arrest, by valid service of summons, or voluntary submission to the court's authority in case of the defendant. Q. Chisi filed a complaint against Chisa. Chisa filed her answer with compulsory counterclaim to counter Chisi's complaint that she did not attach a certificate of non-form shopping. Chisi filed a motion praying that Chisa's answer should be considered as not having been filed at all due to the absence of a certificate of non-form shopping. Chisi filed a motion praying that Chisa's answer should be considered as not having been filed. Decide the motion. What is the effect if the certificate of non-form shopping is not attached to a pleading that requires such? The motion should be denied. A certificate of non-form shopping is not an initiatory pleading, hence not required. The effect if a certificate of non-form shopping is not attached to a pleading that requires such. It is not curable by mere amendment and shall be a cause for the dismissal of action. Section 5, Rule 7. No, when the case is dismissed due to non-compliance with the certification, filing fees cannot be recovered. What is the effect of non-compliance with the undertakings? It has the same effect as a submission of false certification. Hence, such failure shall constitute indirect contempt of court without prejudice to the corresponding administrative and criminal sanctions. Q. Mr. Humpty filed with the regional trial court a complaint against Mrs. Dumpty for damages. The RTC, after due proceedings, rendered a decision granting the complaint and ordering Ms. Dumpty to pay damages to Mr. Humpty. Ms. Dumpty timely filed an appeal before the Court of Appeals, questioning the RTC decision. Meanwhile, the RTC granted Mr. Humpty's motion for execution pending appeal. Upon the receipt of the RTC's order granting execution pending appeal, Ms. Dumpty filed with the CA another case, this time a special civil action for certiorari, assailing said RTC order. Is there a violation of the rule against form shopping considering the two actions emanating from the same case with the RTC were filed by Ms. Dumpty with the CA 2014? The answer is no. There is no violation of the rules against form shopping. The essence of form shopping is the filing by a party against whom an adverse judgment has been rendered in one form, seeking another and possibly favorable opinion in another suit, other than by appeal or special civil action for certiorari. The act of filing of multiple suits involving the same parties for the same cause of action, either simultaneously or successively for the purpose of obtaining a favorable judgment. Form shopping exists where the elements of litis pendentia are present or where a final judgment in one case will amount to res judicata in the action under consideration. Roberto Benedicto versus Manuel Lacson. In Philippines Nails and Wires Corporation versus Malayan Insurance Company, the Supreme Court held that one party may validly question a decision in a regular appeal and at the same time assail the execution pending appeal via certiorari without violating the rule against form shopping. This is because the merits of the case will not be addressed in the petition dealing with the execution and vice versa. Since Ms. Dumpty merely filed a special civil action for certiorari, the same will not constitute a violation of the rules on form shopping because the resolution of or favorable judgment thereon will not amount to res judicata in the subsequent proceedings between the same parties. Roberto Benedicto versus Manuel Laxon. Totality rule. Q. Lender extended to borrower 100,000 peso loan covered by a promissory note. Later, borrower obtained another 100,000 peso loan, again covered by a promissory note. Still later, borrower obtained a 300,000 loan secured by a real estate mortgage on his land valued at 500,000 pesos. Borrower defaulted on his payments when the loans matured. Despite demand to pay the 500,000 loan, borrower refused to pay. Lender applying the totality rule filed against borrower with the Regional Trial Court of Manila a collection suit for 500,000. Did lender correctly apply the totality rule and the rule on joinder of causes of action 2015? The answer is yes. The lender correctly applied the totality rule and the rule on joinder of causes of action because where the claims in all the causes of action are principally for recovery of sum of money, the aggregate amount of the claim shall be the test of jurisdiction. Here, the total amount of the claim is 500,000. Hence, the Regional Trial Court of Manila has jurisdiction over the suit. At any rate, it is immaterial that one of the loans is secured by a real estate mortgage because the lender opted to file a collection of sum of money instead of foreclosure of the said mortgage. What is the object of the Katarungang Pambarangay Law? Its object is to effect an amicable settlement of disputes among family and barangay members at the barangay level without judicial recourse and consequently help relieve the courts of docket congestion. Preamble of PD 1508, the former and the first Katarungang Pambarangay Law, 1999. Question. What is the subject matter for amicable settlement? General rule, the lupon of each barangay shall have authority to bring together the parties actually residing in the same city or municipality for amicable settlement of all disputes. Exception 1. Where one party is the government or any subdivision or instrumentality thereof. 2. Where one party is a public officer or employee and the dispute relates to the performance of his official functions. 3. Offenses punishable by imprisonment exceeding 1 year or a fine exceeding 5,000 pesos. 4. Offenses where there are no private offended party. 5. Where the dispute involves real properties located in different cities or municipalities unless the parties agree to or unless the party agree to submit the dispute to amicable settlement by an appropriate lupon. 6. Disputes involving parties who actually reside in barangays of different cities or municipalities except where the barangay units adjoin each other, and B. The parties submit their dispute to amicable settlement by an appropriate lupon. 7. Disputes with or which the President may determine in the interest of justice, and 8. Where one of the parties is a juridical entity. Q. When may a party directly file an action in court, notwithstanding that said action falls within the authority of the lupon ng tagapamayapa? A party may directly file an action in court in the following instances. 1. Where the accused is under police custody or detention. 2. Where the person has otherwise been deprived of personal liberty, calling for habeas corpus proceeding. 3. Where the actions are coupled with provisional remedies such as preliminary injunction, attachment, delivery of personal property, and support pendente lite. 4. Where the action may otherwise be barred by statute of limitations. 5. Labor disputes. 6. Carl disputes or CARL. 7. Any class of dispute which the President may determine in the interest of justice or upon recommendation of the Secretary of Justice. 8. Disputes involving the traditions of indigenous cultural communities. And 9. Actions to annul judgment upon a compromise. Civil cases covered by the rules and summary procedure. All cases of forcible entry and unlawful detainer, irrespective of the amount of damages or unpaid rental sought to be recovered. Where attorney's fees are awarded, the same shall not exceed 20,000. And number 2, all other civil cases except probate proceedings, where the total amount of plaintiff's claim does not exceed 100,000 or does not exceed 200,000 in Metro Manila, exclusive of interest and costs. Dismissal upon notice by plaintiff. 2 dismissal rule. When does the 2 dismissal rule apply? It applies when the plaintiff has 1. Twice dismissed the actions. Number 2, based on or including the same claim. And 3, in a court of competent jurisdiction. Our statement for the bar, page 265. Note, the second notice of dismissal will bar the refiling of the action because it will operate as an adjudication of the claim upon the merits. In other words, the claim may only be filed twice, the first being the claim embodied in the original complaint. What is the effect of dismissal upon a counterclaim which was already pleaded? Effect of dismissal upon a counterclaim which was already pleaded. 1. If a counterclaim has already been pleaded by the defendant prior to the service upon him or the plaintiff's motion to dismiss, and the court grants the said motion to dismiss, the dismissal shall be limited to the complaint. Number 2, the defendant, if he so desires, may prosecute his counterclaim either in a separate action or in the same action. Should he choose to have his counterclaim resolved in the same action, he must notify the court of his preference within 15 days from the notice of the plaintiff's motion to dismiss. Number 3, the dismissal of the complaint does not carry with it the dismissal of the counterclaim. What rule governs the dismissal of counterclaim, cross-claim, or third-party complaint? The rule on the dismissal of a complaint applies to the dismissal of any counterclaim, cross-claim, or third-party claim. A voluntary dismissal by the claimant alone by notice pursuant to Section 1, Rule 17 shall be made before a responsive pleading or a motion for summary judgment is served, or, if there is none, before the introduction of evidence at the trial or hearing. Q. In a complaint for recovery of real property, the plaintiff averred, among others, that he is the owner of the said property by virtue of a deed of sale executed by the defendant in his favor. Copy of the deed of sale was appended to the complaint as Annex A thereof. In his unverified answer, the defendant denied the allegation concerning the sale of the property in question, as well as the appended deed of sale for lack of knowledge or information sufficient to form a belief as to the truth thereof. It is proper for the court, or is it proper for the court to render judgment without trial? 2005. Defendant cannot deny the sale of the property for lack of knowledge or information sufficient to form a belief as to the truth thereof. The answer being defective amounts to an admission. Philippines Advertising Counselors versus Revilla. Moreover, the genuineness and due execution of the deed of sale can only be denied by the defendant under oath, and failure to do so is also an admission of the deed. Hence, a judgment on the pleading can be rendered by the court without need of a trial. Q. Summons was issued by the Regional Trial Court and actually received on time by defendant from his wife at their residence. The sheriff earlier that day had delivered the summons to her at said residence because defendant was not home at the time. The sheriff's return of or proof of service filed with the court in some states that the summons with attached copy of the complaint was served on defendant as his residence to his wife, a person of suitable age and discretion, then residing therein. Defendant moved to dismiss on the ground that the court had no jurisdiction over his person, as there was no valid service of summons on him, because the sheriff's return or proof of service does not show that the sheriff first made a genuine attempt to serve the summons on defendant personally before serving it to his wife. Is the motion to dismiss meritorious? What is the purpose of summons, and by whom may it be served? The motion to dismiss is not meritorious because the defendant actually received the summons on time from his wife. Service on the wife was sufficient. Buticano versus Chu. It is the duty of the court to look into the sufficiency of the service. The sheriff's negligence in not stating in his return that he first made a genuine effort to serve the summons on the defendant should not prejudice the plaintiff. Mapa versus Court of Appeals. The purpose of the summons is to inform the defendant of the complaint filed against him and to enable the court to acquire jurisdiction over his person. It may be served by the sheriff or his deputy or any person authorized by the court. Alternative answer. Yes, the motion to dismiss is meritorious. Substituted service cannot be effected unless the sheriff's return shows that he made a genuine attempt to effect personal service on the husband. Voluntary appearance. To constitute voluntary appearance, it must be the kind that amounts to a voluntary submission to the jurisdiction of the court. Submission to the court's jurisdiction takes the form of an appearance that seeks affirmative relief, except when the relief sought is for the purpose of objecting to the jurisdiction of the court over the person of the defendant. Examples. 1. When the defendant files the corresponding pleading thereon. B. When the defendant files a motion for reconsideration of the judgment by default. C. When the defendant files a petition to set aside the judgment of default. Or D. When the parties jointly submit a compromise agreement for approval of the court. As a rule, an appearance is whatever form without expressly objecting to the jurisdiction of the court over the person is a submission to the jurisdiction of the court. Carvalho versus Encarnacion. Hence, the filing of an answer per se should not be treated automatically as a voluntary appearance. When the appearance is precisely to object to the jurisdiction of the court over his person, it is not considered an appearance in court. French Oil Machinery versus Court of Appeals, and should not be construed as a submission by the defendant of his person to the jurisdiction of the court. What is the mode of appeal applicable to the following cases, and what issues may be raised before the reviewing court or tribunal? A. The decision or final order of the NLRC. B. The judgment or final order of the RTC in the exercise of its appellate jurisdiction. Answer to letter A. Petitions for issuance of writs of certiorari, prohibition and mandamus to the CA or Supreme Court, concurrent jurisdiction. Note, the petitions must first be filed with the CA, otherwise they shall be dismissed. St. Martin Funeral Home versus CA. Mike failed to pay 6 months' rent. Jonathan filed an ejectment suit. The municipal trial court rendered judgment in favor of Jonathan, who then filed a motion for the issuance of writ of execution. The MTC issued the writ. A. How can Mike state the execution of the MTC judgment? Answer. Executions shall issue immediately upon motion, unless Mike perfects his appeal to the RTC, or B. files a sufficient supersedeas bond to pay the rents, damages, and costs occurring up to the time of the judgment appealed from, and C. Deposits monthly with the RTC during the pendency of the appeal the amount of rent due from time to time. In an action for injunction and damages, to plaintiff applied for a temporary restraining order or TRO and preliminary injunction. Upon filing of the complaint, the court issued a TRO and set the application for preliminary injunction for hearing. As the 20-day lifetime, January 3rd to 23, of the TRO was about to expire, the court issued an order dated January 21st, extending the effectivity of the TRO for another 20 days, January 24 to February 13. On March 5, the court, after hearing, denied the application for preliminary injunction. Supposing that January 28 the defendant committed an act in violation of the TRO, is he guilty of indirect contempt? No, because in order to constitute indirect contempt, the writ disobeyed must be lawful. In this case, the court had no authority to extend the effectivity of the TRO for another 20 days. Consequently, the defendant did not commit indirect contempt by committing an act on January 28 in violation of TRO. The extension was null and void. Carbunco versus Court of Appeals. Exclusive original jurisdiction, recovery of possession, the actions of forcible entry and unlawful detainer are within the exclusive and original jurisdiction of the MTC, METC, and MCTC, RA 7691, and shall be governed by the rules and summary procedure, irrespective of the amount of damages or rental sought to be recovered. Number 2. Enforcement of a seller's contractual right incapable of pecuniary estimation, RTCs. What is annulment of judgment? It is a remedy in law, independent of the case, where the judgment sought to be annulled was rendered. The purpose of such action is to have the final and executor judgment set aside so that there be renewal of litigation. Note, a co-equal court cannot annul the final judgment of a similar court. CA has exclusive jurisdiction over actions for annulment of judgments of RTC. An action to annul a judgment or final order of MTC shall be filed in the RTC having jurisdiction in the former, and it shall be treated as an ordinary civil action. When may it be availed of? The remedy of annulment of judgment may be availed of when the ordinary remedies of new trial, appeal, petition for relief, or other appropriate remedies are no longer available through no fault of the petitioner. What is splitting cause of action? It is the act of instituting two or more suits on the basis of the same cause of action. It is the act of dividing a single or indivisible cause of action into several parts or claims and bringing several actions thereon. It is a ground for the dismissal of others. The rule against splitting of a cause of action aims to avoid multiplicity of suits, conflicting decisions, and unnecessary vexation and harassment of defendants. It applies not only to complaints but also to counterclaims and cross-claims. Note, an action for forcible entry should include not only the plea for restoration of possession but also claims for damages arising out of the forcible entry. Progressive Development Corporation versus CA. Effect of failure to answer. Distinguish between the effects of the failure to file an answer in a civil case governed by the summary rules and in a civil case governed by the regular provisions of the rules of court. Under summary procedure rules, upon the failure to file an answer in a civil case, the court motu proprio, or upon motion of the plaintiff, shall render judgment as may be warranted by the facts alleged in the complaint and limited to what is prayed for therein, except as to the amount of damages which the court may reduce in its discretion. Under the regular procedure, upon the failure to file an answer, the court shall, upon motion of the plaintiff and proof of such failure, declare the defendant in default. Thereupon the court shall proceed to receive the plaintiff's evidence and render judgment granting him such relief as the complaint and the facts proven may warrant. Such judgment shall not exceed the amount or be different in kind from that prayed for. Define jurisdiction. It is the power of the court to hear, try, and decide a case. How jurisdiction is conferred and determined. Q. A complaint filed for recovery of possession of real property also prayed for moral and exemplary damages, the amounts of which have been left to the court's discretion, and for actual damages an amount of which shall be proven at the trial. The docket fees for the action involving the real property have been paid, but not those for the related damages, the amounts of which have not been specified. Did the court acquire jurisdiction over the action? Yes, because the docket fees for the action involving the real property have been paid. May the action be dismissed? No, because the court has acquired jurisdiction over the action. However, the claim for damages, as to which no amounts were specified, may be expunged, or the plaintiff may be allowed to amend the complaint so as to specify the amount of damages and to pay the requisite fees within the prescriptive period. Takei versus RTC. Relation to custody of a minor child. The Court of Appeals has concurrent jurisdiction with the family courts and the Supreme Court in petitions for habeas corpus where the custody of minors is at issue, notwithstanding the provision in the Family Courts Act that family courts have exclusive jurisdiction in such cases. Thornton versus Thornton, Section 20, Paragraph 6 of the SEAM number 0304104. It provides that the petition may likewise be filed with the Supreme Court or Court of Appeals or with any of its members, and if so granted, the writ shall be enforceable anywhere in the Philippines. The writ may be made returnable to a family court or to any regular court within the region where the petitioner resides or where the minor may be found for hearing and decision on the merits. Exclusive original jurisdiction of the MTC under civil actions and probate proceedings, testate and intestate, including the grant of provisional remedies in proper cases where the value of the personal property, estate, or amount the demand does not exceed 200,000 pesos outside Metro Manila or does not exceed 400,000 in Metro Manila, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs. Yes, RTC should dismiss in determining whether an action is one, the subject matter of which is not capable of pecuniary estimation. This court has adopted the criterion of first ascertaining the nature of the principal action or remedy sought. If it is primarily for the recovery of a sum of money, the claim is considered capable of pecuniary estimation, and whether the jurisdiction is in the municipal courts or in the courts of first instance would depend on the amount of the claim. However, where the basic issue is something other than the right to recover a sum of money, where the money claim is purely incidental to or a consequence of the principal relief sought, the court or this court has considered such actions as cases where the subject of the litigation may not be estimated in terms of money and are cognizable exclusively by courts of first instance, now RTC. The principal purpose of the plaintiff in filing the complaint was to secure title to this portion of the property which they purchased from the respondent. Their cause of action is based on the right as purchaser of the subject land from respondent. He prays that he be declared owner of the property sold. Thus, their complaint involved title to real property or any interest therein. The alleged value of the land which they purchased was 15,000, which was within the jurisdiction of MTC. The annulment of the deed of sale were prayed for in the complaint because they were necessary before the lot may be partitioned and the 50 square meter portion subject thereof may be conveyed to petitioners. Doctrine of primary jurisdiction. Courts will not resolve a controversy involving a question which is within the jurisdiction of an administrative tribunal, especially where the question demands the exercise of sound administrative discretion, requiring the special knowledge, experience, and services of the administrative tribunal to determine technical and intricate matters of fact. On the date when the original complaint was filed, amendments in pleading new defendants retroact to the date of the filing of the complaint because they do not constitute a new case or a new cause of action. In the 1997 Rules of Civil Procedure, if an additional defendant is impleaded in a later pleading, the action is commenced with regard to him on the date of the filing of such later pleading, irrespective of whether the motion for its admission, if necessary, is denied by the court. In splitting a cause of action, the pleader divides a single cause of action, claim or demand into two or more parts, brings the suit for one of such parts with the intent to reserve the rest for another separate action. Quadra versus CA. The rule against splitting a cause of action and its effect is that if two or more suits are instituted in the basis of the same cause of action, the filing of one or a judgment on the merits in any one is available as a ground for the dismissal of the others. Isolated transaction rule. Only foreign corporations and not just any business organization or entity can avail themselves of the privilege of suing before Philippine courts even without a license. The owners of property over which reconveyance is asserted are indispensable parties and must be joined in the action. Indispensable party is a real party in interest without whom no final determination can be had of an action. Without the presence of his party, the judgment of a court cannot attain real finality. De Castro vs. CA. The presence of indispensable parties is a condition for the exercise of juridical power, and when an indispensable party is not before the court, the action should be dismissed. The absence of indispensable party renders all subsequent actions of the court null and void for want of authority to act not only to the absent parties, but even as to those present. In this case, B, not an indispensable party because petitioner can claim indemnity directly from respondent, having made itself jointly and severally liable with B for the obligation. Therefore, the failure to implead B is not a ground to dismiss the case, even if the same was without prejudice. In instances of non-joinder of indispensable parties, the proper remedy is to implead them and not to dismiss the case. The non-joinder of indispensable parties is not a ground for the dismissal of an action. Divina Gracia versus Perelia. The obligation is joint, indeed, if from the law or the nature of the wording of the obligation the contrary does not appear, an obligation is presumed to be only joint, that is, the debt is divided into as many equal shares as there are debtors, each debt being considered distinct from one another. Clearly, the liability of X and Y is merely joint, since the obligation of X and Y spouses is chargeable against the respective conjugal partnerships, the unpaid balance of such be divided into two. Venue of real actions, actions affecting title to or possession of real property or interest therein shall be commenced and tried in the proper court, which has jurisdiction over the area wherein the real property involved is a portion thereof is situated. Forcible entry and detainer actions shall be commenced and tried in the municipal trial court of the municipality or city wherein the real property involved or a portion thereof is situated. It should be filed in Bontoc Mountain Province where the real property is located. Number 14, venue of personal actions. All other actions may be commenced and tried where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendants resides, all at the option of the plaintiff. Number 15, this is an answer to a quiz actually. This is a personal action. In personal action, the plaintiff seeks the recovery of personal property, the enforcement of a contract, or the recovery of damages. In the case at bar, it is clear from the parties' contract that the venue of any action which they might bring are the courts of competent jurisdiction in Pasay City, whether the action is for breach of the lease agreement or damages or any other cost between lessor and lessee, the persons claiming under each. The language used leaves no room for interpretation. It clearly evinces the parties' intent to limit to the courts of appropriate jurisdiction of Pasay City the venue of all suits between the lessor and the lessee and those between parties claiming under them. This means a waiver of right to institute action in the courts provided for in Rule 4, Section 2. Section 12, bringing new parties. When the presence of parties other than those to the original action is required for the granting of complete relief in the determination of a counterclaim or a cross-claim, the court shall order them to be brought in as defendants if jurisdiction over them can be obtained. The counterclaims may properly implead respondents L and M even if both were not parties in the original complaint. Summons must be served on respondents CCC, L, and M before the trial court can obtain jurisdiction over them. The correct procedure in instances such as this is for the trial court, per Section 12 of Rule 6 of the Rules of Court, to order such impleaded parties to be brought in as defendants, if jurisdiction over them can be obtained, by directing that summons be served on them. In this manner, they can be properly appraised of and answer the charges against them. Only upon service of summons can the trial court obtain jurisdiction over them. CCC's motion to dismiss the counterclaim on behalf of respondents element is not allowed, while respondent CCC can move to dismiss the counterclaims against it by raising grounds that pertain to individual defendants Slim and Mariano. It cannot file the same motion on their behalf for the simple reason that it lacks the requisite authority to do so. A compulsory counterclaim does not require a certificate of non-form shopping because a compulsory counterclaim is not an initiatory pleading. Cruz Agana Petitioner versus B. Serrano. Adverse party does not appear to be a party to the instrument. Compliance with order of inspection of original instrument is required. Default, declaration of default. If the defending party fails to answer within the time allowed, therefore, the court shall, upon motion of the claiming party with notice to the defending party and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment granting the claimant such relief as his pleading may warrant, unless the court, in its discretion, requires the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. Leave of court is required for substantial amendment made after service of a responsive pleading. The plaintiff, for example, cannot amend his complaint by changing his cause of action or adding a new one without leave of court. Calo and San Jose versus Roldan. X may not amend his complaint as a matter of right because there is already a responsive pleading filed. According to the rules, a plaintiff has the right to amend his complaint once at any time before a responsive pleading is served by the other party, or in case of a reply to which there is no responsive pleading, at any time within 10 days after it is served. Thus, before an answer is served on the plaintiff, the latter may amend his complaint as a matter of right. Tune in for the next upload. I will be uploading Remedial Law Q&A for 2018. And if you're not yet subscribed to our channel, go ahead and hit that subscribe button and let's study together. Thank you.